Morning.
Welcome to First District Court of Appeals oral arguments. So the first case that we have today is In Re RAD et al. And that's case number C200325264444546. Now I acknowledge that we have several attorneys here this morning to argue on behalf of the appellant and also on the behalf of the appellee. So before you introduce yourselves, because acknowledging that we do have and we want everyone to be heard, we're going to allot 20 minutes for each side, okay? And you can split the 20 minutes however you choose. And of course, we don't have the benefit of being live where you could talk with each other. So if you want to take I'm willing to take a pause so that the appellants can discuss and decide how they will split the 20 minutes, and then we'll take a pause for the appellees to do the same, and then we'll continue, okay? So for the appellants, you're free to go ahead and decide how you're going to split your 20 minutes amongst yourselves, and then you'll let us know on the record.
Thank you. Do you want us to can we discuss it here in Zoom, or do you want us to call each other?
You're able to, aren't you able to like chat?
Good idea.
And Your Honor, I have one preliminary matter. I would ask to be able just to submit on my brief. I'm not feeling good today. I have a doctor's appointment. I'm the N. Ray Williams attorney for one of the children who pretty much has indicated that she just does not want to proceed any further.
Okay, and that is fine. And we, of course, received your brief and we've read your brief. And so hopefully you will be feeling better soon and everything will go well and not a problem, understandable.
Thank you, Your Honor. May I be dismissed?
Absolutely.
Thank you.
I can't figure out how to chat except to everyone.
Okay. Let me see if, and maybe it's because if you go to where it says everyone, there's a little arrow next to it. If you drop down that arrow, it doesn't allow you to put in individual people. Okay, all righty.
I think we've settled it with Cynthia's chat. I'm fine discussing it here. I mean, my argument's going to be brief. I think Cynthia's going to use 5 minutes. I probably will only use 5 minutes.
Yeah, mine's pretty straightforward.
Okay, so I'm not sure that I followed.
Phyllis, perhaps?
So Attorney Doherty, you're going to have how many minutes?
At the most, 5 minutes. Mine's pretty straightforward, Your Honor.
Okay, and Attorney Trelevin?
5 minutes, please, Your Honor.
Okay, and is Attorney Kirk here?
He was, Your Honor, or there he is. His video is just not on.
Okay. Attorney Kirk? Attorney Kirk, you have your volume off. Okay. I'm not sure if, because I see someone saying Roger, I'm assuming that's Attorney Kirk. I don't know who this will be. Okay, well, on behalf of the appellees.
Your Honor, Dick Varney for Hamilton County Jobs and Family Services. My argument as well is pretty straightforward. As a preliminary.
So how many minutes are you going to take?
5 to 6 at most. I don't see Ms. Schiff signed in. I believe Ms. Schiff is part of this case.
Okay, so because I have Attorney Costin for the GAL, so Attorney Costin.
Correct.
And you'll take about how many minutes do you think?
5 or less, Your Honor.
Okay, so alrighty. So let's go ahead and now be a little bit more formal. And so, we're still here on case number C200325246, 44, 45, and 46. For the appellants, if each one of you can please identify yourself and who you're representing.
Cynthia Doherty, I am representing Miss McCurdy, who is the custody petitioner for Rayana Davis.
Thank
Only
you,
one
Attorney.
child.
Thank you, Attorney Doherty. And you'll be arguing first, is that right? No?
I was under the assumption that the mother's attorney would argue, but it doesn't matter to me. I can argue first if Your Honor would prefer that.
Mother's attorney, Attorney Schiff, has submitted on the briefs.
Yes, Your Honor. I can argue first.
Okay.
John Treelevin for Tyree Fagan, father, and Trina Fagan, great aunt and petitioner of I think there's multiple RDs, but of Renila only.
And you'll
Judge Zayas, could I interrupt for just a moment?
absolutely.
Because we are live on YouTube, may I make a suggestion to counsel and to the court that we not use the full names of the children? And normally, if we were an open court, that might be different, but we are streaming live on YouTube and it will be archived. So that's just my suggestion to everyone.
I apologize, Your Honor. I was trying not to. I just didn't know how to identify otherwise with the multiple RDs.
Sure. I mean, you know, I know that some of the initials wind up being very similar. The other way that you can also address is, you know, third oldest child and things, you know, in that nature. And that will also be understood if that makes it easier. Okay. Attorney Doherty, whenever you're ready.
Yes, Your Honor, if it please the court. Good morning.
Absolutely.
I think I already indicated I represent Miss McCurdy, who is related to, I will call this child RAHD because she has a couple of middle initials. And she is a cousin to that child's father. Miss McCurdy filed a custody petition in this case back in 2018. That custody petition was denied. Miss McCurdy has cared for this child. The child is 6 years old, and she had cared for the child intermittently during her life, including extended visits and time at her home for at times 3 weeks at a time. She set up all doctor's appointments. She'd taken the child to doctor appointments and cared for her, food, clothing, etc. Became part of her family in and out of the home. During this case, the RAHD was placed with Miss McCurdy for approximately.
Is this the second oldest child? Am I recalling that correctly?
She's 6. So the other, I'm not on the other children, but her
Okay.
initials includes an extra a name. So she has 4 initials instead of 3.
Okay.
Sorry about that.
And it's RAHD. Yeah, that would be that's the second oldest child. So if it's easier for you, feel free to refer to her in that nature as well.
Thank you for that assistance, Your Honor. So the second oldest child was placed with my client for approximately 3 weeks during the course of this case. And case plan services were put in place, including therapy. However, my client lives in the inner city and always has a job for 14 years there, raised her children there, no negative history whatsoever, and only drives within her neighborhood, and that's all that she knows. The therapy was placed at Children's, and it was for the second oldest child to attend therapy in Westchester, Ohio. My client has no idea how to get to Westchester. I think the agency wanted her to get a GPS system, that kind of thing. But however, my client continually requested to have the therapy moved to the Clifton office to have therapy there. But she also had the care source issue with transportation. They tried to come and pick up the child and take the child to therapy in Westchester. However, the care source never got the address for my client. So my client received continual threats of removal over the course of these 3 weeks. because she couldn't get her to the therapy in Westchester.
And during those 3 weeks, was JFS aware of the situation?
Your Honor, that's part of what the argument is that my client was on the stand and gave testimony that she has these videos on her phone. She's unrepresented in this trial. She doesn't know, it's just an unsophisticated cousin coming in. She attended all the hearings and she kept saying, I have these videos, I have this information to negate what the caseworker's testimony was, and that evidence wasn't considered. She had been communicating. She also had been communicating with the transportation services, and they kept saying, we cannot pick her up because we don't have your address on file. So the other issue in this case as to the removal and the denial of the custody petition has to do with the caseworker indicated that when he picked up the child, she was outside by herself with her belongings. Then later says she was outside in the hallway at the top of the stairs with her belongings. Yet my client has text messages that would indicate differently. So that also wasn't considered at trial. So even after the second oldest child was removed from my client, she continued to come to hearings. She never missed a hearing. She still wants to remain involved with the child, still wants custody of the child. So we're just asking for this court to reconsider this and either reverse the decision and award custody to my client or remand it back for at least consideration of the evidence that my client has in order to negate the testimony of the caseworker.
And just for clarity, was she represented at the hearings?
No, Your Honor, she was not represented and she cannot afford an attorney. She's, like I said, she's inner city. She's lived there. She works a kind of factory job, been there 14 years. Her children are excellent. She's never had any issues. Her daughter is in the U.S. Air Force. Her son gets excellent grades in the school there in town. So she's one of these individuals that sort of stay and live in their own neighborhood. Everything she does is within that neighborhood. She drives, but you know, for her, it's an anxious thing to go all the way to Westchester. That's not part of her lifestyle, never has been. But she tried to get transportation set up and the care source was never moved to her address. So she has letters from children saying, hey, can you request the therapy to be moved to Clifton? And that, I mean, she's in trial saying, I have this stuff with me. It's over there. It's in my file. Do you want it? You know, she doesn't know what to do. She's unrepresented. She's just doing the best she can.
And did she file objections to the magistrate's decision?
She did. She did. She did all that on her own, and she kept coming to court and kept saying, I have videos of me calling this caseworker. I have this stuff. And, you know, why aren't they looking at it? But when you're unrepresented, she just doesn't know what to do. I think she did a great job considering she wasn't unrepresented to as far as she took it this far. But she would like at least consideration of the evidence that she has. There is no reason why this child shouldn't go with this cousin. She's familiar with the cousin. She's been in her home an extended time. The cousin set her up on WIC. She set her up on daycare. She set her up on all the doctor's appointments. All that stuff is out there to be gotten if we really want to. And, you know, it's
so
not
ultimately, just for clarity, what evidence ultimately with regard to your client is part of the record?
I think
you shared with us things that could have been, but are not, that possibly could have been, but what actually is in the record?
I think her testimony of the events that happened, that it's not true that this child was left outside. And her testimony saying, you know, I have these letters. Some of that was considered, but most of it was not.
Thank you.
Thank you, Your Honor.
I don't know if there's any other questions from the panel.
With that, I'll submit.
All right, thank you. Thank you for your argument this morning. Attorney Tree-Levin?
Thank you, Your Honor. And may it please the court. I represent both father and great aunt, but both are advocating for the same outcome in that great aunt would receive custody of the oldest child. And the oldest child is the only child I'm referencing in my arguments.
Yeah. Now, the father did file objections, the father that you represent, is that correct?
Correct.
And the aunt did not, is that correct?
I believe she filed them, but did not submit an argument on the objections. We submitted written arguments due to the pandemic on this case, but we did not argue in person. But I believe she did object, but did not submit an argument.
So you believe that she had filed objections that were separate? They're either separate or filed conjunctively with that of father?
Yeah, at the time, I did not represent her, and so she was proceeding pro se. It became a difficult situation for me where my client was advocating for a position where the other party needed to take steps to maintain his position. And I believe she had filed an objection, but I don't think she submitted a written argument.
Okay, all right, thank you.
And in regards to their position, our main argument would be that juvenile court continually misses a preliminary and important step in regards to the best interest argument. And that is codified in section 215101, which is that it's the liberal interpretation and construction statute setting up juvenile court and the custody constructs. And it says, whenever possible, you need to keep a child in a family environment and separate the child from the parents only when it's necessary for the child's welfare. I'd highlight the fact that it doesn't say when it's in the best interest of the child. It says whenever possible, keep it with family and only separate if necessary. Too often we lump this concern in with the best interest analysis, but from our perspective, it's a threshold question. Can this child stay with her family? Can this child maintain a relationship with her father or her mother or any other relatives? And in this case, what's tantamount to a rules violation ends up permanently severing those familial bonds. In this case, the case plan is used obviously to set up the constructs of visitation and placement and all of that for the child. And in this case, the case plan that was originally filed creating visitation with great aunt had a little bit of conflicting information in it. And it was somewhat addressed during trial. The court sort of moved on from it quickly, but acknowledged in trial that it's part of the record. And the restrictions in that case plan in regards to the oldest child with visitation, there's a specific section of the case plan that says, state the restriction on visitation and or supervision, explain the reason for any restrictions on the location, frequency, and duration of visitation and or the need for supervised visitation. And that section's blank in the case plan that was filed February of 2019. Now in the next section, there's sort of a catch-all other approved communication section. And in that section, the case plan that JFS filed says, and it says her name, but it says, great aunt will not allow father to visit until he is cleared with the agency. Great aunt will supervise all visitation with adults not approved by the agency. So in the same breath, they say he can't visit, but that great aunt will supervise his visits, but they don't even put it in the correct section. And then the visits start and the JFS caseworker unilaterally terminates them. There's a vehicle that he could have appropriately terminated them through an emergency case plan filing. That didn't happen. He just terminated the visits before any court action was taken. And you get in this situation where the agency is penalizing great aunt for rules violations, but then they're not following the rules themselves. And it makes it a little bit murky in regards to how families should approach the court when there's a different set of standards for the agency and for them. And I think that was where a lot of frustration came out of this case, is that there wasn't a clear communication either way. And I think it's patently unfair to hold that against a family.
What is your position as to what should have occurred?
So what should have occurred is there's two things that JFS missed. One, in that initial case plan filing, there's a section for them to restrict visitation. They should have put the restrictions on visitation in that section. They didn't. Now, whether they made it clear or not to great aunt and by other means is a different question, but everyone knows the case plan is the vehicle that drives that. It's a contract essentially. But more egregious is how they terminated the visits. They just stopped them. There was no court order to stop them. They just stopped them. And in the middle of a permanent custody proceeding, that's essentially resolving the issue extrajudiciously without taking the appropriate step of going to the court. And there, you can file an emergency case plan that will be heard that day or within 72 hours, asking to terminate the visitation.
Oh, wait a minute. I see the mute button. Now, do we not hit that? So it had to go off.
Attorney Kirk, if you could please mute yourself. We're in the middle of arguments.
I'm sorry, Your Honor. I was having technical problems. I was trying to get my phone to work.
Okay.
Sorry. My apologies. I didn't realize it was coming through. I couldn't get my side of the phone to work.
You want me to proceed, Your Honor?
Yes, please.
So they could have done it that way in filing the emergency, and they should have done it that way in filing the emergency case plan, but they didn't. They just stopped the visits and waited to come back to court on a case plan objection. So from our perspective, JFS was very casual in setting up this visitation and in terminating it. And for them to be so casual in regards to it, but then cite it as the reason why great aunt can't have custody is extremely problematic from our perspective. And in the end, great aunt is still a definite possibility for custody of this child. There's nothing in the record that shows otherwise. She was approved by the agency for placement and unsupervised visitation. Nothing happened.
So I want to clarify something, Attorney 211. It's so on the second point, because your first point has to do with where the visitation, the restrictions visitations was contained within the case plan. Okay. So I'm addressing your second point, which has to do with stopping the visitations in the way that it was procedurally. So I want to clarify, is it your position that it was required for the case plan to be modified before the visitation with aunt could be terminated?
Correct. It's a court order. The case plan becomes a court order when it's adopted by the court. Mm-hmm. And so if JFS just unilaterally stops the visitation, they're in violation of that court order. There's a vehicle for them to stop it immediately. They didn't choose that route. Instead, they just asked the court to address it in time. It's just like an initial custody petition. You can file on an emergency basis, or you can file just a regular petition and have it play out in a more normal time setting. And so they were aware of it. They had the option and they didn't do it. And so, yeah, the way they stopped the visits technically violated the court orders.
Thank you.
And I guess the bigger point for me is in the testimony in sort of the real world, that JFS testified absolutely no harm was done to the child by father having contact when great aunt was exercising the parenting time. She broke a nebulous rule is the best case scenario for the agency. And I don't know if we should be permanently altering the trajectory of a child's life because of a rule violation. We're asking the court to give great aunt custody. JFS can monitor that custody extrajudiciously. It's not like the agency's interaction in this child's life ends. It's a situation where it's imminently plausible for great aunt to get custody here. It's definitely possible, which is really what the statute is asking you to do. And so that's what we would be asking for today. Thank you.
Isn't it a little bit more than a rule violation where the father had already been deemed to have abandoned the child and the father did not engage in services?
It's a rule on her parenting time. And if we're talking about considering her for custody, if you're asking if it goes to the best interest of the child, I'd say in regards to the parenting time, they need to be clear that the father of the child can't be around. I don't know what more it would be than a rule violation, because if you're questioning her judgment, it wasn't clear in the case plan. And so I'd say JFS's judgment wasn't clear as well. The rules to her weren't clear. To me, it is a rule. Well, I guess you could argue it's a violation of a court order, if the court has adopted that case plan. However, my point would be that court order is a little bit vague and hazy, and it sort of speaks against itself the way that the agency wrote it. And so I don't think it goes to her protective capabilities, because you heard Job and Family Services testify that there's no harm to this child by father having contact. And so I think it would be tough for them to argue it should go to her protective capabilities, because the manner in which father had contact, even though it may have violated this rule, JFS themselves testified that it did not cause any harm to the child.
Thank you for your argument this morning. I'm
Thank you,
going to turn to Attorney Kirk and see if perhaps he can come back on.
I'm here, Your Honor. Can you hear me?
I could. I don't know if you were able to hear us at the onset where we were trying to divide time and get your response. Unless there's objection from anyone, I'm happy to give you 5 minutes to argue.
Your Honor, I appreciate that. And I apologize for I just have problems with the technical aspects of
I
Zoom.
understand. I understand. I mean, we're all trying to accommodate the situation.
Thank you, Your Honor.
We're no longer doing live arguments for obvious reasons.
Yeah, it's a different world, but I don't even have, if it pleases the court, I represent appellant DeMarco Cooper, father. I don't even have 5 minutes of argument. My whole brief was in essence to support mother's position. Mr. Cooper never did advocate for himself because he had some incarceration problems. He was viewed as the domestic violence aggressor, these kinds of things. He just didn't want to have the children placed in foster care or permanent custody to the agency. He was wanting the mother to have custody, or even Mr. Treelevin or some of the other petitioners that from the relatives. And that's in essence his entire argument. And I was just going to submit on that, to be honest with you, unless you have other questions, Your Honor.
Unless there's questions from the panel, from the other members. Okay. Well, thank you for tuning in and for your argument this morning.
I tried, Your Honor. Thank you.
And you know what? I totally overlooked asking if anyone wanted to reserve time. Attorney Treelevin, do you want to reserve?
I mean, I overlooked it as well.
At this point, it's kind of funny we're talking about reserving time, but.
I guess I'd asked to reserve 2 minutes if I've still got them left.
Okay. And Attorney Doherty?
Same here if it's necessary.
Okay, all righty. Well, we'll go ahead and move into argument from the appellees. And so I assume that Attorney Varney will be arguing first.
Yes, Your Honor, that works for me.
Okay, whenever you're ready.
Good morning, Your Honors. May it please
Good
the
morning,
court.
and I appreciate your flexibility this morning.
Oh, absolutely. Thank you to everyone here. Nick Varney for Jobs and Family Services. I think I'll curtail my argument just to focus on the 2 children that we're discussing this morning, just for clarity. I think the other 2 children are explained well enough in my brief for the court's consideration. And I'll start with Ms. McCurdy as it relates to I have her captioned as RAH-D because I think she's the only child with a hyphenated last name, or the second oldest child. Certainly, I think the record is complete with many references to how hard Jobs and Family Services and the guardian worked to maintain familial placements in this case. I was at a disadvantage. I was not the prosecutor that tried the early part of the case. I appeared on the last trial setting, and there was a number of trial settings, but in reviewing the case, it was clear to me that Jobs and Family Services, and particularly the trial guardian at Lightham, had a lot of contact with family members, were very communicative with them about what the expectations were. So under that auspice, I would say that with regard to Ms. McCurdy, it was made clear to her that JFS did not choose Westchester intentionally as the location where the therapist who was assigned to the second oldest child was located.
Well, let me ask you this. Like, I have some sympathy for the concern about going to Westchester. I don't like going to Westchester. 75 is always a nightmare. It takes forever. And we have a multitude of healthcare providers frankly, in and around downtown. So, when you're dealing with people with modest means who may not have the best transportation, like, why are we faulting them for not wanting to trek all the way up to Westchester?
I don't think that that point in and of itself, Your Honor, is the reason why JFS found her position to be unreasonable. I think that the child was in her home for 20 days. Ms. Doherty argued that this woman had this bond with this child that was far beyond, just the time that JFS was involved, and they offered different solutions to this situation. I think that were reasonable under the circumstances, up to and including bus tokens, care source transportation. There may have been issues with getting the address cleared. As we know, services through Medicaid sometimes can take some time. I'm not placing that on the petitioner. However,
bus tokens, how long would it take to get by bus to Westchester? That'd probably take all day.
I can't speak on that. I've never, ridden the bus.
But I think the broader point though is, are we setting these people up to fail, or are we setting them up to succeed? And I would submit that if you were requiring someone who doesn't have transportation to get all the way up to Westchester, which could literally take a couple of hours if you're going by bus, I just have real concerns about that. And I know that that's probably broader than this argument, but it troubles me that's what seems to be an issue here.
I understand where Your Honor is coming from. I think that's more of a systemic issue, and unfortunately, that is raising its specter in this argument. However, I think JFS's position from a more pointed aspect is that 20 days, this child was placed in this home, and during that 20 days, after that 20 days, Ms. McCurdy requested them to just come and pick up the child. Now, whether the child was at the top of the stairs in the apartment building or outside the apartment building, the fact of the matter is a 3-year-old child was basically, you're out of here, you're leaving, a 3-year-old child. I don't think that's reasonable. I think that Ms. McCurdy could have worked with the agency in trying to move the appointments to a different office in the inner city. I understand that she had transportation issues, but on one hand, to say, I need all this help, I'm asking for help, I have videos which weren't submitted, I have evidence which wasn't submitted at trial to prove that I'm throwing my hands up and asking for help, and then 20 days later to say, I love this child, but you're out of here, I think is kind of talking out of both sides of the petitioner's mouth here, Your Honor. And this is a 3-year-old child. We're not talking about a 12-year-old. We're not talking about a 15-year-old. This is a 3-year-old. I think that the sum and total of Ms. McCurdy's argument is that at the end of it, she requested removal of the child. JFS did not threaten to remove and then follow through on that threat. She called JFS and said, come pick the child up. That's clear in the trial record. It's clear in the judicial entry. I think the court can refer to that. With regard to Ms. Fagan, I think it is also a little bit of an oversimplification to say that it's a rules violation. There was extensive testimony before the trial court and before the judge that the guardian ad litem and JFS made clear to Ms. Fagan that there was a reason they were disallowing Mr. Fagan from being around the child, given that he was incarcerated from 2012 until his release during the pendency of the permanent custody trial.
Was that made clear at the time that the case plan was formulated?
At the time the case plan was formulated, Your Honor, Mr. Fagan was incarcerated. So there was no way for him to engage in case plan services. And then upon his release, when he appeared at court and was appointed an attorney, it was made clear to him that he needed to engage with JFS, needed to meet with the caseworker and begin that conversation.
When he was released, was the case plan modified?
I do not know the answer to that question, Your Honor. I assume that if they were requesting services of Mr. Fagan or setting up visitation, that they would have addressed that and amended the case plan to reflect those things. But I think with both the petitioners, what we have here, Your Honors, is there has to be a level of trust between the agency and folks who are petitioning for custody. And in this case, Ms. Fagan made clear that she would not allow Mr. Fagan into her home on the weekends that she had visitation time with the oldest child. And instead of following through with that, she let father stay overnight. And then both she and father told the child to not tell their caseworker or their guardian that that had happened. In fact, they asked the child to lie for them. When the child mentioned that to her foster placement, the foster placement notified the GAL, who notified JFS, and a conversation took place. It was determined that at that point, that was not a positive environment for the oldest child to be in. And so they terminated the visits.
Was
Certainly,
there any evidence in the record that the dad posed any danger to the child?
I do believe Mr. Trelevin is correct. I think the testimony was that there was no harm done to the child during that visit. However,
Well, the question is whether there was potential harm. Was there any evidence in the record that the dad could pose danger to the child?
I don't think there were any specifics listed, Your Honor. I think it was simply the fact that he had been incarcerated for violent crimes and had not engaged with the agency in any way. And in fact, went around the agency and asked his aunt and the child to lie so that he could visit with the child outside of the bounds of visitation that was made clear in court by JFS and by the guardian.
Was there any evidence as to why they had told the child to withhold that information from JFS? What was their explanation as to the why?
That was the child's report to the guardian and to the foster placement. So I think that I would be inferring if I were trying to imagine how that conversation took place. But I know that the young child mentioned to multiple professionals that the aunt and the father asked her to not mention to anyone that visit had taken place, which I think sort of endorses that both knew that it was incorrect and that they shouldn't have allowed that visit to take place. And again, there's a good deal of evidence in the record that the guardian and JFS testified that they had clear and open conversations with the aunt that those visits were not to take place in that manner. And then they did in a very short time after those visits were instituted. So I think to prevent any future harm, whether that be physical, psychological, or emotional to the child. And I think JFS's position is reasonable in this. They wanted to evaluate father where he was, given his multiple incarcerations and the natures of his crimes. They wanted to make sure that that was going to be a healthy interaction for the child. And I think that's reasonable. And the family sort of circumvented that process, which is why those visits were terminated, and why ultimately, back to my issue of there has to be a level of trust between JFS, who is the custodian for the children, and the potential custodians who are seeking custody of these children. I think both with Ms. McCurdy and with Ms. Fagan, certain expectations were set, those expectations were not met, and in different circumstances caused those placements to disrupt. And
if I can ask you this, how would you address Attorney Trelevin's argument that the change of visitation or the termination, in this case, the termination of visitation, necessitated for JFS to go to court and to get a court order or modify the case plan?
My argument is this, Your Honor. The folks that write these case plans are not attorneys. They're not trained in the sophisticated language of court orders and motion practice. And if there was an issue with the case plan, there's certainly a vehicle that is very convenient to parties to the case, which is to object to the case plan and ask that the magistrate hear the objection. The magistrate can then hear the conflict over the wording or whatever the issue is about how JFS stated that. I understand where Mr. Trelevin is coming from, but that was never objected to. It was never asked to be clarified. And so,
that might be an argument addressing the onset of the case plan and the wording of the visitation and the placement of the visitation. But what I was addressing was the termination of the visitation.
Your Honor, certainly that should have been an emergency case plan. I can't say to this court that there was a good reason for why it wasn't done the way it was supposed to be done. However, I think the sum and total is that the court eventually heard the evidence that it needed to hear with regard to why those visits were terminated. And the court agreed with JFS and the judge agreed with JFS after two separate objection hearings for why the visits were terminated. On top of the fact that this was not a placement, this was just weekend visitation to potentially place the child in the home. And the idea being—
You're saying that that by it being raised in the objections and heard in the objection, that cures the fact that there wasn't an emergency case plan before the termination of visitation? Is that what I'm understanding your argument to be?
I suppose that's my argument. I think the sum of the argument is that the reason for the stopping of the visits, it wasn't a secret. The court had the information. Now, getting to that point to argue why the visit should be terminated, certainly it could have been done more cleanly, could have been done more to the book, but the substance of those arguments was heard by the court, and all parties had an opportunity to present evidence and testimony about why the visits were terminated and how they were terminated. And ultimately, the magistrate and the judge agreed with Jobs and Family Services in terminating those visits.
Okay. Thank you, Attorney Barney. I don't know if there's any questions from the panel. Okay. Attorney Costin, good morning again.
Good morning, Your Honors. James Costin, representing the attorney GA.
Uh-oh. You froze for a second.
I am over in the main courthouse and the Wi-Fi sometimes is not the best over here. So if there's any issues while I'm talking, let me know.
Okay.
Your Honors, I think the attorney GAL would echo Job and Family Services arguments that were just made to you with respect to Ms. Fagan and Ms. McCurdy. I think with respect to Ms. McCurdy, the attorney guardian ad litem noted that this child was removed not at the request of JFS or by the actions of JFS. The child was removed at the request of Ms. McCurdy. So I think the trial court has to weigh, the commitment of the petitioner to the child to determine what is in the child's best interest, and Ms. McCurdy's own actions were evidence enough to show that she was not committed to the child, and that is evidence that is of a weight that is sufficient for the trial court to make its decision. With respect to Ms. Fagan, I think it's important to note, I didn't point it out in my brief, but I believe it is in the trial record in the transcripts that father, before his visitation was terminated, was offered the chance to meet with the caseworker down at the agency to get his visits approved. And instead of doing that, he decided to be sneaky, in essence, not do that and go through the back door and try to visit his child without letting the agency assess whether or not his visits would be in the best interest of the child to begin with. So,
Mr. Costin, can I go
yes.
back to Ms. McCurdy for a minute?
Uh-huh.
Could a reasonable inference also be that she was so committed to this child when she realized that she was unable to get her to her medical appointments, she thought that the child really needed those appointments, and the only way she was going to get them was to turn her back to Job and Family Services?
That could be an inference, but I don't see that that evidence is in the record, Your Honor, to draw that inference.
Was there any testimony from her that would indicate she realized she couldn't get them there and she knew that the child needed to go?
Well, I think she recognized that the child needed to go. I think that she recognized that it was in the best interest of the child to attend the therapy. I would agree that that is in the record. What's also in the record is that JFS was in the process of trying to get these services transferred. There was a 20-day period. I think it's in the record that they were in the process of trying to get the services transferred down to a more accessible location for her. But regardless of that, she terminated the placement on her own. And this is all what's not reflected, I believe, in any of the parties' arguments, is that this is all process that is going on within this time frame of this permanent custody framework that's in the statute. My reading of the record is that all of this stuff is happening quickly in order to meet these time requirements prescribed by the statute. That accommodations were made, The attorney GAL was trying to make arrangements, have meetings with these family members to get these goals accomplished for these children. And because of the actions of the petitioners, those things just didn't pan out. And so that was the basis for the GAL's determination, as reflected in her recommendation to the court, that permanent custody was in the best interest of the children.
With regard to Ms. Fagan, is there any evidence in the record that that she was aware that father had been offered an opportunity to have visitation and to engage in services and had refused to do so, or had chosen not to?
I don't recall reading that specifically, that was either her testimony that she knew that happened. I believe that was the caseworker's testimony, that he had advised father that he would be considered for visitation, but that they wanted to meet with him first at the agency to discuss that. And before that even occurred, the aunt allowed him to attend the visit when she had been instructed both by the attorney GAL and the caseworker not to have that happen. And then the child was instructed to lie about it. And once again, I think, the trial court, magistrate who's trying the case, has to assess, the commitment that petitioners display towards raising these children in a safe way. And their actions alone sort of belie their stated commitment to the child.
Thank you.
And with that, I'll submit. Thank you very much.
Okay. Okay, thank you for your arguments. I'm going to now turn to rebuttals. Attorney Doherty, is there anything that you would like to address in your 2 minutes?
Yes, Your Honor, thank you. I think two things stand out for me. One is that Ms. McCurdy did indicate that she had been threatened by the agency to remove the child. And because of that, she wanted a more controlled removal instead of a rip and tear. She wanted to know when they were coming. So that is, and I think that is in the record. I think she explains that in her testimony, or she attempts to. But I think to mischaracterize that as I love you, but you're out of here, or a non-commitment to this child is unfair. And the other thing is that they're correct in that the second oldest child was placed with Miss McCurdy for 20 days. I said 3 weeks, close to 3 weeks. So we gave this an effort of a whole 3 weeks. So how much therapy did this child actually miss in that? But the attorney for the GAL indicates this timeline and needing to get things done quickly, but yet the record shows 3 amended complaints. It shows incorrect records. I think that's in my brief, where the magistrate actually indicates on the record that the second oldest child is still with my client when she had been removed months earlier. So doing things on a timeline and expeditiously, I'm not so sure is necessarily accurate. Again, my client and the record in her testimony indicates that she has evidence to indicate otherwise, and what her intentions, thought process, and care for this child was. I think that's there. There's another question as to whether or not the GAL ever visited Miss McCurdy. So that's all that I have. Thank you.
Thank you. Attorney Trelevin?
Thank you, Your Honor. First, I would clarify, I was able to review the docket statement, and great aunt did not file an objection. The court was, I think, correct in the pointed nature of its question, but she did file a notice of appeal, and father's position all along has sort of been to advocate for great aunt. And so I don't think you're looking at plain error here in regards to great aunt, because father has advocated all along. And obviously his rights are impacted when great aunt's rights are impacted, residual rights to visitation, support, things like that. And
So
so,
with great aunt not filing objections, does father have standing for that position?
so I would argue yes. I know the case law. I'm aware of the case law. I would argue yes because of what I just said. You have an issue where fathers' residual parenting rights are impacted if we're saying that he doesn't have standing to argue here. It's a situation where great aunt has filed a notice of appeal, is still present in the case, is still asking for custody here, and it's not to excuse perhaps me missing it, but it's a situation where we were not going to court at all at the time. So I had absolutely no access to JCMS. Attorneys like me only have access to the court system when we're in the courthouse. And at that point, we weren't allowed in the courthouse. And you have a bunch of e-filings and a litany of objections that are filed. I was under the impression she had filed an objection. From the record, it looks like she has not. But I would argue he does, because she's filed the notice of appeal. She's still active in the case, and his residual parenting rights are obviously impacted if we're saying he doesn't have standing or she doesn't have standing to argue here. And I would argue almost even on a plain error analysis here, you need to look at this from the 10,000 foot view, in that it's a situation where no harm came to this child when great aunt was visiting with her. No harm at all. And it's eminently possible to place this child with her. The case plan wasn't clear. The case plan objection wasn't handled correctly.
The problem is, under plain error, it's a very, very, very high threshold, because we're bound to the plain error as articulated under civil cases.
Understood. I'm making the main argument here I'm making is that yes, he still has standing, and great aunt, in regards to the fact that father filed an objection, putting all the parties on notice that he was advocating for great aunt, I think maintains both of their positions because they have been aligned. You also wade into the issue of great aunt never had counsel during the trial, was never afforded counsel during the trial. And if you're not affording these petitioners counsel through appointments, then it makes it tough on parents who are seeking to protect their residual rights, because you have to have unrepresented parties taking steps that they may not be aware of to protect their rights. And so I think.
So how about with regard within the confines of plain error, how would you argue that there is plain error that's undermining the integrity and the confidence of the system?
You gotta give me 1 second, but I think
Absolutely.
that I think that when you have a situation where you're likening it to the death penalty of family law, it's the most grave situation you can have. And you have a case plan that is inherently unclear as to what this visitation should be. And then you have a procedure where the visits for this great aunt are terminated, and that's not handled correctly. It's handled in a situation where JFS should have made a filing and they didn't do it. I would liken it to, in the criminal context, in a murder trial, if a judge sua sponte granted a motion to suppress at trial. I think you'd say plain error if this was a murder case. And so in this case, I'd say you have the agency unilaterally stopping great aunt's visitation, which effectively grants the permanent custody motion. If great aunt is not visiting with the child, the court isn't going to grant custody at the end to great aunt. And so JFS takes this unilateral action that ostensibly denies great aunt a chance at getting custody, which in turn denies father's constitutional right to parent and a constitutional right to exercise his residual parenting rights. And so I think the manner in which it was handled, you could make an argument that it arises to plain error, in that families in the community would be questioning the validity of this process. And like I said, when you're talking about the death penalty of family law, we need to cross all the T's, we need to dot all the I's. The only metaphor I could draw would be if a judge, excluded evidence at trial without, I guess that's the defendant, but without going through the steps of a motion to suppress or something akin like that, where there's a unilateral step taken by an actor that works against the person who has due process rights. Thank you.
Okay, thank you everyone for your arguments this morning. we are going to take the matter under submission, issue a timely decision, and we wish everyone a wonderful afternoon and a wonderful 2021.
Thank you, Your Honor.
Thank you, Your Honors.
Thank you, Your Honor.
Good morning.
Morning.
Is Attorney McIntosh in? And Attorney Kirk, if you can be so kind as to disconnect.
Yeah, yes, Your Honor, I'm trying to.
I gotcha. Well, maybe, Mark, maybe you can, as the host, disconnect Attorney Kirk and help him out, please. Thank you.
Done.
Um,
Your Honor, if I may, I
Yes,
did
please.
speak to Mr. McIntosh yesterday, who indicated to me that he was not feeling well and wanted to submit. I told
Okay,
him that at the he called me very late in the day, and I told him the best way for him to do that was to make a personal request to the court this morning. But he hasn't even logged in, so.
all right, thank you. Thank you for the information. Well, I mean, if he's articulated that he's not feeling well, my question to Attorney Halden is whether you would like to submit on the brief?
I'm completely fine with that.
Okay.
I don't
And
have
I
any
assume you don't have any objection
No,
to
no.
the appellant submitting on the brief?
None.
Right. Okay, well then I apologize that you've had to wait all this time.
Oh, I'm here. That's fine.
Well, we appreciate it. We appreciate you being so kind with your time. And we wish you a wonderful afternoon. We'll take the matter under submission and issue a timely decision.
Thank you, Your Honor.
And have a wonderful 2021.
Yeah, you as well. Thank you.
Thank you.